Welcome. My name is Gianluca Parolin, and I'm delighted to welcome you to the Aga Khan University Institute for the Study of Muslim Civilizations in London. As a faculty lead on the governance program, I'm particularly delighted to welcome you to this seminar on the proposed reform to introduce gender equality in inheritance in Tunisia. In systems where inheritance regulations have been inspired by classical Islamic jurisprudence, debates over gender equality in inheritance have been going on and off for quite some time. In the last few years, the debate has reignited, most notably in the western part of North Africa. Yet, only in Tunisia, the debate lingering in civil society has been taken up by state institutions, which initiated the reform process. A process that is now in an advanced stage, yet nowhere near completion, as we will hear. At the governance program, we are interested in exploring how decisions are made in the public sphere, both in terms of content and in terms of process, especially when such choices touch upon particular sensitive issues to sections of the population. We are therefore thrilled to have with us this distinguished panel of scholars to discuss the process and the content of this divisive reform. I'm particularly grateful to the dear friend and colleague Salwa Hamrouni for being with us. Not only is she a committed professor of constitutional law at the University of Tunis, Carthage, but was also an influential member of the commission appointed by the presidency to put forward a few proposals to address the issue of gender equality in the Tunisian regulations of inheritance. It has not been easy to secure a visa for Salwa's visit, and I wish to thank His Excellency, the Ambassador of the Republic of Tunisia to the UK, Mr. Nabil Ben Kheder, and the Deputy Head of Mission, who is with us, His Excellency Anwar Ben Youssef, for their help. The three other stellar scholars who will engage in the discussion with Salwa come from other corners of Europe, from where we do not have issues with securing visas yet. Roberta Aluffi will focus on the content of the proposal, bringing in her expertise on classical regulations. Dörthe Engelcke will offer insights from the Jordanian perspective of reforms of inheritance law. And Nadjma Yassari will consider the context in which the process of legislative reform unfolds. I will introduce them in due course. Speaking of visas and travels, we are particularly honored to have with us in the audience colleagues who made the trip from continental Europe and all the way from Brazil just for the workshop. There are also colleagues from the other side of the pond who didn't make the trip on purpose, but we're just as delighted to have them with us. This is even truer for those of you who came here by the lift or some other sort of public transportation in our rainy town. As for the format, we will start with a 30-minute presentation by Salwa, followed by 10-minute responses by Roberta, Dörthe, and Nadjma. I will then give back the floor to Salwa for her first round of responses, and if all goes to plan, we will have a solid half hour for Q&A from the audience, so do jot down your questions. One further final piece of information, Salwa will be presenting in French, but her presentation will be accompanied by slides in English. Based on her notes, I will give you a quick preview of her presentation before giving her the floor. Then I will do a brief recap in English after she's done. Salwa Hamrouni is Professor of Constitutional Law at the University of Tunis, Carthage, and as you know, as I already told you, and she was the member of the COLIB, you will hear a lot in French, the commission that drafted this report. So her presentation will fundamentally cover the aspects of process and content. So she will first tell us how this debate about gender equality in inheritance has taken this institutional structure of the commission, what or how the Commission decided to go about this task of putting in line Tunisian legislation with the requirements of the 2014 Constitution and international law that is a requirement by the Tunisian Constitution itself. And then she will move on to see how that process actually generated, of course, that process did not only look at inheritance, it looked at a much wider set of issues. So I asked her to just focus on inheritance. So then she will tell us how that proposal that was handed to the president in a public ceremony was transformed into a draft bill, and that was approved by the Council of Ministers and then was sent to Parliament for debate. So she will tell us about that. That is, what has the draft law picked up from the proposal of the Commission that she was a part of, and then she will also look at what are the issues that the draft law is now facing. So, as we usually say, without further ado, I'll give her the floor. I apologize for the two languages thing, but the slides will be in English, and we'll try and make it work.
Merci beaucoup, Gianluca. Merci pour l'université, Aga Khan Université. Je suis désolée parce que je vais parler en français, parce que je ne maîtrise pas l'anglais. Donc, je vais essayer de ne pas aller vite, peut-être s'il y a des gens qui arrivent à capter ce que je dis. Alors, je suis contente que le débat sur la question de l'héritage qui a eu lieu en Tunisie se transforme ou s'exporte en dehors de la Tunisie, non seulement dans d'autres pays arabes, mais aussi dans les universités et ici l'université européenne. Alors, pour commencer, je rappellerai que le débat sur l'héritage en Tunisie a commencé durant les années 90. Et cela a commencé dans le cadre de la société civile qui n'était pas du tout écoutée par le pouvoir à l'époque et qui était un débat restreint dans une élite limitée à des cercles très très restreints. Alors, ce n'est que le 13 août 2017 que le débat a commencé à se démocratiser, j'allais dire, c'est-à-dire à faire l'objet de débats un peu partout en Tunisie et surtout un débat dans le cadre des institutions officielles. Alors c'est pour cela que le 17 août 2017, le président de la République a décidé la création d'une commission appelée Commission des libertés individuelles et de l'égalité. Je rappelle tout simplement que la commission n'avait pas seulement pour fonction de travailler sur l'héritage, vous l'avez présenté maintenant, mais sur la question de l'égalité. Mais je précise quand même que pour le chef de l'État, dans son discours du 13 août 2017, la seule chose sur laquelle il a focalisé, c'était l'héritage, même si la commission allait traiter d'autres choses. Bien sûr, c'est une commission ad hoc, donc elle a rendu son rapport le 8 juin dernier et elle n'existe plus en tant qu'institution. Elle était composée de 9 membres, dont 3 juristes, dont je suis moi-même partie, et un anthropologue, des gens qui viennent du monde de la communication, des islamologues également. Et donc c'était une commission un peu diversifiée quant aux spécialités. Alors la mission de cette commission, c'était de préparer un rapport sur les réformes relatives aux libertés individuelles et à l'égalité, en s'appuyant sur les dispositions de la Constitution de 2014, mais aussi sur les orientations contemporaines en matière des libertés et de l'égalité. Et cette mission qui existe dans notre décret de création nous a permis d'aller très loin, c'est-à-dire d'aller au maximum en termes de liberté et d'égalité, puisque les normes de référence de cette commission, c'était la Constitution et les engagements internationaux de la Tunisie. Alors, avant 2014, Avant 2014, la Constitution de 1959 prévoyait également le principe de l'égalité dans son article 6. La Constitution de 59, contrairement à la nouvelle Constitution, parle de citoyens, donc elle n'a pas féminisé le langage, donc c'est pas un langage inclusif, c'est tout à fait normal, ça date de 1959. Mais l'article 7 renvoie à la loi l'organisation des droits des citoyens et vous pouvez deviner, en l'absence d'une cour constitutionnelle, le législateur tunisien a pu violer la Constitution parce qu'il n'y a pas un juge qui constate cela, qui lui interdirait cela. Il y avait aussi, avant 2014, mais jusqu'à aujourd'hui, le Code du statut personnel de 1956, un code dont la plupart des femmes tunisiennes sont fières, et j'en suis partie, mais c'est un code qui a quand même évolué sur beaucoup de questions, sauf sur la question de l'héritage. Il y a eu une seule fois où la question de l'héritage a été touchée, mais Bourguiba a eu le courage en 1956 d'interdire la polygamie, de faire le mariage civil, de faire beaucoup de choses. Et sur la question de l'héritage, il n'a pas traité de cela parce que apparemment on lui a dit à l'époque, et contrairement à ce qu'on dit, c'est pas parce que c'est contraire à la religion, mais parce qu'on lui a dit que ça va susciter des réactions tribales, parce que la société était largement tribale et on voulait pas donc disperser l'héritage en fait, ou les terres, les biens. Alors je vais traiter de trois questions. Je commencerai par le processus qui a mené à l'adoption de ce projet de loi, et c'est très important de comprendre le processus, ça permet de voir comment est-ce que ce projet est venu. Deuxième question, les normes de référence, et troisième question, les propositions en tant que telles, c'est-à-dire qu'est-ce que la Commission a proposé, mais surtout qu'est-ce que la loi prévoit aujourd'hui, le projet de loi, je veux dire. Alors, le processus. Une question fondamentale a été traitée par la Commission, c'était comment faire accepter le projet par le maximum de personnes. Pour cela, il fallait fédérer, il fallait avoir une approche participative, il fallait inviter toutes les institutions, toutes les ONG, tous les militants, tous les enseignants, les spécialistes dans le monde académique qui sont intéressés par cette question. Donc notre souci, ce n'était pas seulement faire un texte juridiquement beau, acceptable, cohérent, ainsi de suite, qui nous convient parfaitement à nous, mais aussi un texte politiquement acceptable, c'est-à-dire qui peut passer. On avait le choix, soit faire quelque chose de parfait et laisser ça dans nos tiroirs, soit faire quelque chose qui n'est pas parfait, qui est une transition, qui est un pas vers l'égalité, mais qui peut être accepté. Donc, cette approche participative a eu lieu grâce à des auditions, plusieurs auditions qu'on a organisées tout au long de cette année de travail. On a commencé par les structures étatiques, mais des structures étatiques indépendantes. Aujourd'hui, en Tunisie, nous avons les instances constitutionnelles indépendantes, les instances publiques indépendantes. Il y a beaucoup d'organisations qui travaillent dans le domaine des droits humains, donc on les a invités. Des structures gouvernementales, évidemment, c'est le gouvernement qui a validé à la fin notre projet, donc c'était important de traiter avec les ministères, avec les ministères de la Justice, des Affaires religieuses, des droits de l'homme, le ministre de l'Intérieur, notamment pour ce qui est des questions des libertés individuelles. Nous avons également discuté avec les partis politiques, pas tous, on a plus de 200 partis en Tunisie, mais on a choisi ceux qui étaient représentés à l'Assemblée, logique, parce qu'on pense qu'eux, ils vont voter la loi. Les associations, les experts, les professeurs de la Zeytouna, et là je m'arrête un peu pour expliquer parce que en fait on a été attaqué le plus par un groupe de professeurs de la Zeytouna, mais ce qu'il faut dire, ce que les gens n'ont pas vu, c'est qu'il y a notre groupe, il y a d'autres enseignants, d'autres experts dans le domaine qui sont venus nous voir, qui ont exprimé leurs avis, qui nous ont donné des arguments et qui nous ont soutenus. Donc, il y a ça. Et bien sûr, il y a les journalistes et les médias, parce qu'on comptait aussi sur eux pour expliquer le projet. Deuxième point, les normes de référence. Alors, la Constitution, évidemment, ce qui est certain, c'est que notre Constitution, texte consensuel, donc par définition, c'est un texte qui, sur certains points, nécessite une interprétation. On n'a pas de cours constitutionnel jusqu'à aujourd'hui, mais c'est un texte qui appelle beaucoup d'efforts d'interprétation. Je commencerai par le préambule où on garantit la primauté de la loi, le respect des libertés et des droits de l'homme, l'indépendance de la justice, l'égalité de tous les citoyens et citoyennes en droit et en devoir. Ça, c'est fondamental. Le préambule fait partie intégrante de la Constitution. L'article 21 est encore plus explicite. Les citoyens et les citoyennes sont égaux en droit et en devoir. Ils sont égaux devant la loi sans discrimination. Donc c'est un article qui dit clairement, qui met à la charge de l'État le fait de garantir cette égalité. Nous avons le fameux article 46 également. Alors, l'article 46 commence par un rappel d'une obligation de protéger les acquis de la femme. Il ne faut pas oublier, ces acquis ont été menacés après la Révolution, les acquis de 56, sur lesquels on pensait que c'était irréversible. Donc, finalement, ce n'était pas ainsi. Donc, protéger les acquis de la femme et consolider ces acquis. Consolider. Donc, déjà, on a vu que dans le fait d'aller vers l'égalité dans l'héritage, c'est une manière de consolider ces acquis et de les promouvoir. L'égalité des chances, la parité dans le domaine politique et à la fin, donc, l'interdiction de la violence à l'égard des femmes. Juste une parenthèse ici, certains, où on peut, je pense, voir que l'inégalité en matière d'héritage peut être considérée comme une violence économique à l'égard des femmes, et notre loi sur la violence à l'égard des femmes définit la violence d'une manière large, elle y intègre la violence politique, mais aussi la violence économique. Les engagements internationaux sont notre deuxième point de référence. La Constitution prévoit que les conventions sont supérieures aux lois, et là, nous avons, comme la plupart des pays, ratifié le pacte des droits civils et politiques, mais également la CEDAW, la Convention sur l'élimination de toutes les formes de discrimination à l'égard des femmes. Donc cette question des normes de référence était fondamentale, et ce qui est clair dans la Constitution de 2014, c'est qu'en aucun moment, notre Constitution ne parle de Sharia. La Constitution tunisienne, elle fait référence à l'islam, oui, à plusieurs reprises, mais durant l'un des projets, il était question de Sharia, il y a eu un débat et il y a eu un refus où on a exclu la Sharia. Comment est-ce que la Constitution traite de l'islam? Moi, je pense que c'est très important de voir comment est-ce que la Constitution tunisienne traite de l'islam. Est-ce que c'est une source de législation? Est-ce que c'est une source formelle? C'est une source matérielle? Donc, puisqu'on n'a pas la Sharia, qu'est-ce qu'on a en contrepartie? Alors, nous avons dans le préambule une référence aux enseignements de l'islam et à ses finalités. Enseignement, personne ne sait ce que c'est exactement. Est-ce que ça s'arrête aux 5 devoirs du musulman? Est-ce que c'est l'esprit de la religion? Ses finalités, donc, aussi, mais en même temps, c'est un texte qui renvoie aux principes universels et supérieurs des droits de l'homme. Et sur la question de l'islam, on parle de notre histoire, du mouvement réformiste éclairé, ainsi de suite. Donc c'est un concentré, le paragraphe qui est devant vous, c'est un concentré de choses qui peuvent être vues comme étant contradictoires, mais qui peuvent parfaitement être en harmonie. Donc il suffit d'avoir une lecture ouverte et s'attacher aux finalités de l'islam, et dans notre rapport on a essayé de le démontrer. On a démontré au moins que la discrimination, c'est pas une finalité de l'islam, qu'à la fin, l'islam, il veut l'égalité. Alors, nous avons aussi les deux articles problématiques en Tunisie. L'article 1er qui dit que la Tunisie est un État libre, indépendant et souverain. l'islam et sa religion, l'arabe, sa langue, ainsi de suite. Et l'article 2, qui tout de suite après, pour ceux qui ont pensé que la Tunisie serait un État islamique, on dit non. Beaucoup d'États, même en Europe démocratique, disent que la religion catholique est la religion de l'État ou du monarque. Donc ça ne fait pas pour autant que l'État soit un État religieux ou qui applique la religion. L'article 2 confirme cette interprétation. La Tunisie, c'est un État civil. Et un État civil, il est défini ici. C'est un État qui est fondé sur la citoyenneté, la volonté du peuple et la primauté du droit. Déjà, si on s'arrête au terme citoyenneté, on comprend que ce qui est fondamental dans un État civil, c'est que les gens sont pris en raison de leur citoyenneté et non pas en rapport avec d'autres appartenances liées à la langue, à la religion ou autre. Donc il faut lire en fait ces deux articles ensemble. Alors, comment est-ce qu'on a utilisé ces normes de référence? Dans quel sens on les a utilisées? Je prends que l'exemple de l'héritage. Alors, dans l'introduction du rapport, on a quand même essayé de démontrer que l'égalité n'est pas contraire à l'islam. Je précise une chose, c'est que dans ce rapport, il y a à peine une vingtaine de pages où on traite de la question religieuse. Et dans cette introduction, on a essayé d'expliquer à ceux qui pensent que l'égalité dans l'héritage serait contraire à l'islam, à leur expliquer, en partant de versets, d'interprétations, de faits historiques liés à la pratique des sahaba, ainsi de suite. On a utilisé l'introduction comme un moyen pédagogique pour s'adresser à ceux qui pensent que l'égalité dans l'héritage serait contre l'islam. Donc on a utilisé des versets qui s'adressent également à l'homme et la femme. On a traité de la répartition des biens et le partage de l'héritage dans la Sharia, comme quoi ça se base sur trois critères. D'abord le degré de parenté des héritiers, la situation générationnelle et la responsabilité matérielle. Donc même en islam, le fait de dire qu'on accorde à la femme le double, à l'homme le double de la femme, c'est lié à des obligations qui sont à la charge de l'homme aussi. Alors, donc, dans cette introduction, on a essayé de démontrer que si la discrimination contre les femmes était une règle fondamentale de l'islam, il n'y aurait pas de cas où les femmes hériteront d'une manière égale. On a recensé 8 cas où les femmes héritent exactement comme l'homme, ou alors, dans certains cas, supérieurs à l'homme. Ceci dit, je m'arrête un peu sur cet argument parce qu'on le sort parfois, ce sont des cas très rares. Statistiquement, ce sont des cas très très rares. Donc la majorité des cas, c'est la femme qui hérite la moitié. Alors, les arguments liés au fait que les versets de l'héritage sont fixes et catégoriques sont des arguments principalement utilisés par la majorité des théologiens pour rejeter toute ouverture et toute discussion à ce propos. Donc, ce qu'il fallait faire, c'est il fallait dire on doit arrêter de dire que le texte est clair et catégorique. Parce que le texte n'est pas clair, parce que la preuve, c'est qu'il a plusieurs interprétations, mais il y en a une qui a dominé pendant des siècles, parce qu'elle correspondait à des intérêts d'une société patriarcale, et parce qu'il y avait des raisons économiques, sociales, derrière cela, et pas tout à fait, ou pas seulement, en tout cas, des questions religieuses. Donc ça, c'est très important, c'était très important de l'expliquer. Alors, je passe rapidement, je ne vais pas m'arrêter sur tous ces détails, mais on a montré que dans la pratique des différents khulafas, on a trouvé des cas où certains califes se sont écartés d'un texte qui était clair, qui était net dans le Coran. Donc, lorsqu'il y avait une nécessité pour dépasser ces textes-là, ou pour le contourner, ou pour ne pas l'appliquer pendant un moment, les califes, qui étaient donc les plus proches du prophète, ont su interpréter le texte d'une manière qui soit conforme aux exigences de l'époque. C'est ça l'idée. Et nous avons cité donc plusieurs cas où la pratique a été, s'est écartée, tout simplement, s'est écartée, il faut le dire, du texte qui était clairement prévu par le Coran. Donc finalement, on a conclu que l'héritage, c'est une question foncièrement sociale, c'est une question qui concernait le partage des richesses, et donc parce qu'il s'agit de partage de richesses, c'est une question qui a éloigné la société de la spiritualité. C'est pas une condition fondamentale. Donc la question de l'héritage, c'est pas une question liée à la foi, c'est pas une question liée à la spiritualité, c'est une question qui est liée au rapport entre les gens. Or, les rapports entre les personnes évoluent, et donc il n'y a pas de raison pour que la question de l'héritage n'évolue pas. Juste pour terminer sur cette question historique, si vous voulez, ou liée à la lecture de la religion, il y a beaucoup de textes qui ont été écrits, même jusqu'à récemment, qui démontrent que même la fille du prophète a été privée d'héritage, et qu'elle a contesté cela, et donc qu'il y a eu un problème parce qu'il est question de partage de richesse, plus que c'est une question de conviction ou de foi notamment. Alors à partir de là, pour revenir au choix que nous avons fait, en fait, nous sommes, d'abord, on a recommandé de revoir tout le chapitre relatif à l'héritage, parce qu'il est long, hein. On a des dizaines d'articles dans le chapitre relatif à l'héritage dans le Code du statut personnel. Donc, il faut tout repenser, parce que le fondement même de la question de l'héritage, c'est la question, c'est l'existence de fils ou de frères de sexe masculin. Donc c'est toujours en fonction de ce qu'on appelle atasib en arabe. Et donc là où il y a un homme, là où il y a une femme, la ligne de l'héritage est interrompue. Donc ça c'est fondamental dans ce système qui est lié. Donc nous, on n'avait pas le temps de tout reprendre, parce qu'il faut tout reprendre, parce qu'il faut s'attaquer au noyau de ce système inégalitaire qui est basé donc sur un privilège de la masculinité, si j'ose dire, et on s'est limité, donc on a recommandé de revoir tout ça, mais on s'est limité aux cas les plus courants, les cas les plus courants, donc les enfants entre la fille et le fils, les parents entre le père et la mère, les conjoints, époux, épouses, et entre les frères et les sœurs, avec une autre proposition que je n'ai pas citée ici, pour l'enfant dit naturel, parce que l'enfant naturel en Tunisie, malheureusement, il n'hérite pas aujourd'hui, et ça c'est une interprétation qui a été faite par les juges. Alors, partant de là, on a fait au départ 3 propositions, mais la loi, on n'a gardé qu'une seule pour le projet de loi. Première proposition, c'est la plus catégorique, mais c'est la plus, je dirais, correcte juridiquement. C'est la position de l'égalité. Donc, garantir l'égalité par la loi pour les filles, les petits-enfants, les mères, les filles et les sœurs. La loi dit tout simplement qu'ils héritent d'une manière égale. Bon, ça c'est la première proposition. Deuxième proposition, on a dit que, ou pensant que, et c'est ça qui a été retenu en réalité, qu'il y aura de la résistance face à ce changement. Donc on a proposé d'assurer l'égalité. Donc le principe, c'est que la loi, l'État qui est État civil, l'État qui doit garantir le respect de l'article 21 que j'ai cité tout à l'heure. Donc l'État doit garantir l'égalité, mais en donnant à la personne en question le droit de s'opposer à l'égalité, donc le futur de juge, si j'ose dire, donc de s'opposer à l'égalité de son vivant, avec des procédures bien sûr qu'il faut suivre. Donc c'est pas un système de choix en réalité, je tiens à expliquer ça, c'est pas une dualité de système juridique, non, le système c'est l'égalité. Si on veut sortir de l'égalité, donc c'est une exception, il faut suivre une procédure bien déterminée. Troisième proposition qui était très contestée, mais j'avoue moi-même qui n'était pas possible, je pense, c'était, on s'est dit, on assure l'égalité juridique seulement lorsque l'héritière la demande. C'est-à-dire c'est l'inverse de la deuxième position. On garde l'inégalité et celle qui veut l'égalité, elle la réclame. Personnellement, je suis convaincue que dans la pratique, ça va être très difficile de mettre en œuvre ceci. Je sais déjà que les femmes tunisiennes, beaucoup de femmes aujourd'hui, ont du mal à avoir le tiers qui leur est dû pour 30 000 raisons, hein, y compris sociologiques, psychologiques, ainsi de suite. Et donc, c'était pas très un choix à retenir. Donc, on a retenu notre proposition dans le projet de loi, c'est la deuxième proposition, le principe, l'égalité, l'exception. Si la personne pense que la discrimination est au cœur de sa foi, elle n'a qu'à dire, voilà, je reste dans le statu quo. Alors aujourd'hui, suite au rapport, ceux qui ont suivi cette question savent évidemment que le rapport a fait l'objet d'une campagne de dénigrement même des personnes qui ont travaillé sur ce rapport. Il y a eu énormément de mosquées qui se sont mobilisées contre le rapport, qui ont des imams qui ont déclaré clairement, versé à l'appui évidemment, qu'il n'est pas question de toucher un verset qui est clair, qui est net, ainsi de suite. Et ce sont des critiques qui nous ont ramené en fait à ce qu'on a vécu avant la Constitution de 2014. C'est-à-dire, on s'est retrouvé à discuter est-ce qu'on applique la Sharia ou pas en Tunisie, alors que c'est une question que nous avons tranchée par la Constitution de 2014. Alors, le projet a été finalement validé par un Conseil de ministres en novembre 2018. Donc, vous avez compris, le président de la République n'a gardé que la question de l'héritage, et sur la question de l'héritage, il a pris la position que nous avons proposée dans notre projet de loi. Il y a eu des changements au niveau de la procédure, mais le fond, c'est le projet de la COLIB. Aujourd'hui, c'est un projet qui est discuté au sein de la Commission des affaires sociales. C'est un projet qui a du mal à avancer parce que la commission même traîne un peu dans ce cadre-là. Il y a eu quelques auditions, mais je pense, vous pouvez comprendre aussi que comme nous aurons des élections très bientôt, donc ça sera au mois d'octobre-novembre, il y a un enjeu électoral très important pour les partis, même pour les partis qui se disent démocratiques ou progressistes qui soutiennent le projet, même ceux qui soutiennent le projet font aujourd'hui se font discrets aujourd'hui parce que c'est une période électorale et que c'est très facile, je termine bientôt, c'est très facile d'avoir des problèmes en matière de campagne électorale. Déjà, nous savons qui est contre, qui a dit publiquement qui est contre. Le parti Nava, il a dit publiquement dans la commission qu'il est contre. Mais les autres partis quand même se disent pour, mais rien n'est fait pour faire avancer le projet. Alors le contenu, je répète, on a repris donc le projet qui est déposé aujourd'hui. Le titre renvoie à la révision du code du statut personnel. Donc, il dit pas le titre, c'est le titre du projet de la loi, c'est une révision du code du statut personnel. Et l'article 1er, donc il a repris ce que j'ai dit tout à l'heure, les différents cas d'égalité, sauf que l'article 2 du projet dit que les dispositions ajoutées s'appliqueront si la personne concernée n'a pas précisé de son vivant qu'il souhaite rester dans le cadre de l'actuelle loi donnant à la fille la moitié du garçon. La seule différence ici, c'est que du point de vue de la procédure, notre projet, nous avons dit la déclaration de rester dans le statu quo se fait par un notaire, mais on peut revenir sur cette déclaration, c'est-à-dire si la personne voulait faire de la discrimination et après elle décide de revenir à l'égalité, nous on a dit elle le fait par tout moyen de preuve, c'est-à-dire tous les moyens sont acceptés. Le service de la présidence a pensé qu'il serait mieux de faire ce qu'on appelle le parallélisme des formes, c'est-à-dire il faut aussi, donc pour revenir à l'égalité, il faut le faire devant un notaire. Donc c'est ça l'une des différences que nous avons remarquées. Alors pour conclure, je pense que c'est un projet, personnellement, vous l'avez deviné, qui me tient à cœur, mais je sais aussi que après un moment d'espoir, là on désespère un peu, pour les raisons que je viens d'expliquer. Je sais que ça sera adopté, alors on ne sait pas si c'est dans une année, après les prochaines élections, ça dépendra des rapports de force, mais il y a quelque chose qui s'est passé en 2017 qui est bonne à mon sens, j'essaie d'être positive sur ce point, c'est que avant on parlait de l'héritage dans des cercles plus restreints que ce cercle-là. Aujourd'hui, tout le monde parle de l'héritage, même ceux qui n'y comprennent rien, même ceux qui veulent nous insulter, même ceux qui veulent dire n'importe quoi. Et donc, avec le temps, je pense qu'il y a un effort pédagogique à faire pour que ces gens comprennent que c'est le sens de l'évolution et qu'on ne peut pas parler d'un État démocratique ou d'un État de droit où les citoyens sont traités sur la base d'une discrimination. Voilà, je vous remercie.
So inspired by her visit to London, Salwa decided to brush up her English over the summer. So next time, inshallah, we'll have it in English. So you probably followed most of her presentation on the slide. She followed quite closely the slide. So I think I will just say, because also some of the issues that she raised will be also addressed by the respondents. So I think that most of the things will come up again. So just to give you a bit of a sense, again, if you haven't followed the slides, she focused on the effort of the Commission to basically frame an argument that would be, you said, be pedagogical, right? To sort of create some sort of empathy with the project. You also listed the amount of, so you were working with a mandate to operate within the new directives of the Constitution, of the 2014 Constitution, and you listed a number of provisions that were somehow guiding you. And so those were also, in a way, constraining the work of the Commission, but you did not shy away from the core of the struggle, which were the provisions in the Constitution that related to the position of Islam. And one thing that you underlined was that there was a discussion within the 2014 Constituent Assembly not to change the existing asset of state-Islam relations, and so not to introduce a Sharia provision as we have in many other countries or systems in the region. So in order to somehow respond to that, squaring the circle between the provisions of the Constitution that demanded a certain equality, the role of international law, and the provisions on state-Islam relations, then you talked about the attempt to build an argument that would resonate with those that would be more religiously minded, and then so you gave us a few examples of the arguments that you use, that is with citing references in which women inherit more than men, and also the practice of the first rightly guided caliphs. And then you also somehow reframe the entire issue of inheritance not as strictly religious or strictly spiritual, but rather ingrained in other social structures and dynamics. Yes. And then you somehow moved straight to the proposal of the Commission, which actually offered 3 proposals. And I think we'll hear some of that also in Roberta's comments. And so there was a first, if you wish, bit radical proposal was like, okay, equality across the board. Then a second solution in which you had a default system with an opt-out option, one way, option 2, and the other way, option 3. So you sort of offered a selection of, possibilities that could be followed. And then you told us how that was actually, what was the actual process that again went through state institutions to transform that proposal into an actual draft law. And as you told us, by and large, it was the second option that was retained by the draft law, which is that there is a default system, and you insisted on that. It's not a dual system; it's rather a default system in which you have an opt-out option, in which the default system is equality, and if you want to opt out, you need to record by a notary public your desire. And I don't know if you said it in the presentation, but I think it was in the slide that you can also, of course, change your mind later in your life. That is, you can review your decision there. And then there's the other side, or the actual process that is now as you said, the draft was voted in the Council of Ministers and then was passed in Parliament, and then Parliament is currently debating in the Committee for Social Affairs, right? And you pointed to the two main challenges that are in front of this draft law, which are one, the fact that a very significant political actor declared its opposition to the draft law, and that's the Ennahda party. And second, that the electoral the elections that are going to be held in later this year are probably also not in favor of a prompt adoption of the draft law. Now, you didn't say it. I suspect that the underlying argument there is that it would be too hefty a cost to bear for any political party before any elections to actually go on by supporting and pushing through this draft law. So I think that's where we are, and of course you close with this very clear conclusion that is the challenge from the perspective, of course, of someone who has worked not just on the committee, but with your entire professional and academic life for the question of gender equality, that there is this dual challenge between, you say, democracy and the rule of law, where only citizenship matters, and the state that consecrates this discrimination by force of law. So I hope I didn't do too much injustice. So again, apologies for this, but I think it's also good for us, because my impression is that we generally hear only the voices that speak English. So I think it was good for us also to have a voice that is francophone. So thank you again for doing that, and apologies for the thing. So now we're gonna it's you. My next task is to introduce the first respondent, who will take us to the. There's a lot of fun slides here. Not much text, but the design, because of course the matter of inheritance, as we know, we don't know the status of that hadith. People they say nusf al-ilm, it's half of science. And then I won't cite the latter part of the hadith, because that Salwa will not be happy. But so it's really half of the science. Every time my head blanks out, it's like inheritance, I can't do it. The only person who can is Roberta, so we're very actually, no, it's not the only person on earth, but at least, so she will actually look at the content of the proposed draft law in view of the previous arrangement of the that was in the Code of Personal Status, but also having in mind the regulations in classical Islamic jurisprudence, which is actually what, and here is the presentation, which is what Roberta Aluffi teaches at the University of Turin, Faculty of Law, where she's associate professor in comparative law. So it's my pleasure to invite her to the microphone. Okay. So to the bottom one.
I need some air.
Yeah.
Ah, thank you. That's wonderful. Thank you so much. I'm happy to be here this night, and I would like to, I would thank Gianluca Parolin for inviting me. I will address some technical issues with the draft law. And why so? Because the Commission, for the Commission, this draft law is but a first step of a double-step path to equality. The Commission talks about a completely non-discriminatory system to be reached in some way through broader consultation, and for the moment, this draft is what it suggests to adopt. This final or definitive solution will be based on a completely new philosophy, but the Commission does not say much about this philosophy. I guess that the idea is also to adopt completely new concepts, categories, to solve the bonds with the traditional toolbox of fiqh. As the, let's try, yes. Actually, the draft law make use of traditional categories and tools. And as far as I understand, the Commission went far on the path of equality using those traditional tools. For example, it sticks to the categories of sharers and residuaries or agnates. Sharers are the heir taking one allotted share, and agnates take the whole of the estate or the residue after the sharer take their shares. So these categories are maintained. The pillar of the reform is to abandon the principle that the male receives twice the portion. Anyway, it's quite easy. Anyway, it will come again, I'm sure. Anyway, the principle was that the male receives twice the portion of the female, and this principle was abandoned. But, as we know, this principle governs the agnatic succession, and only the agnatic succession as that. So the Commission had to use other measures to get to equality. For example, shares are made equal. The wife's share is made equal to the husband's share. Or sharers are transformed into residuaries, and residuaries are transformed into sharer. Let's think, for example, of the mother. The mother is normally a sharer, but it is treated as an agnate in order to share with the husband the residue or the whole of the estate. An heir, an agnate or a residuary who is transformed in a sharer is the father in the presence of the daughter. So normally the daughter is the sharer and she takes one half of the estate and the father takes the rest. But according to the draft law, the father becomes sharer, he takes 1/5 or 1/6 of the estate, and the daughter becomes an agnate. You recognize the solution for the son. That is to say, the presence of the daughter has the same effect as the presence of a son. Please look at the third column there. We were told that the system is a default system with an opt-out possibility. This is true only for agnatic succession, that is to say, for the principle that the male takes twice the portion of the female. There, the propositus can opt out, but not for the other measures. No way for the husband to opt out in order to have his wife receive just a quarter or 1/8 of the estate. So it's really something very well done, in my opinion. Here is homemade, I'm sorry. It was... well, it is true that the Personal Statute Code was very faithful to the classical law. Nonetheless, 2 reforms were introduced, and now the draft law reforms the 2 reforms. The first one concerns the daughter. It's the same, I mean, what we have, what I said for sister and father is true also for a sister. Daughter and father is true for daughter with other agnates, more distant agnates in classical law. The solution is perceived as particularly unfair by not only daughters but also fathers. And throughout the Arab world, fathers try to preserve their daughters' rights in different ways. Think, for example, that in Lebanon, fathers would pass from Sunnism to Shiism in order to exclude distant agnates. What was done by the Code of Personal Status in 1959 was to adopt the mechanism of Rad, which is Hanafi, and the mechanism of Rad is that mechanism which allows, in the case where shares do not exhaust the entire estate and there are no agnates, for the residue to return, Rad, to the sharers and be divided in proportion of the shares. So this is not a mechanism known in Maliki law. It was adopted with the exclusion of distant agnates by the daughter. So the daughter now, under the current law, receive half of the estate as a sharer and the other half by way of Rad. The same solution, substantially, is the solution proposed by the draft law. That is to say, the daughter takes all, but as if she was a son. Then, you have, maybe I'm a little bit late, but anyway, the other reform was made in favor of the grandson by way of al-wasiya al-wajiba, mandatory will. It was very complicated. Now the grandson is no more excluded by the son, but it's in place of his father. So this is according to the draft law. The heir who profits the most from the draft law is the wife, not only because of her share being the same as husband's share, and this is mandatory, but also because of the dwelling rights on the marital home, which is for the husband too, but the wording is not so clear. Anyway, I have no time. But these rights are conditional on the duration of marriage and presence of children. I think personally that these conditions are very reasonable, but I cannot understand why we cannot extend them to the husband too. Another discrimination, last slide, it's, which is maintained by the draft law, is the discrimination among siblings. In Islamic law, you have to distinguish full siblings and half siblings. Leaving aside full siblings, you have half siblings, uterine and consanguineous. Consanguineous siblings exclude uterine siblings. Why? That's clearly a question of gender discrimination. It is because motherhood is not the same as fatherhood. Fatherhood is more powerful, it is stronger. So there is a reason to exclude uterine siblings in the presence of consanguineous siblings. I have a last slide, but it's not important. I was informed that the draft law under discussion in the Tunisian parliament does not comprehend the part on the equality of children. So the part on legitimate and illegitimate children, and so the intertwining between equality of children and gender equality is not our topic tonight. Thank you.
Thank you, Roberta, and apologies for trying to sabotage your presentation. I actually didn't know, I didn't pick up from the text that there's this attempt to go for representation of the predeceased parent for instead of the wasiya wajba. So that would go down the Pakistani option. Oh, that's fantastic. Anyway, so our next speaker actually takes us out of Tunisia, and her book is just out on family law reform in Morocco and Jordan, and that's where she will take us, Jordan, and how the debate on gender equality in inheritance has somehow been addressed within the wider debate on family law reform in the country. So Dörthe Engelcke is senior fellow at the Max Planck Institute in Hamburg on which is the Max Planck for private and comparative law. All right, please.
Thank you. Yeah, I didn't prepare a PowerPoint, so I think I'm just gonna sit. Yes, so actually the Tunisian case, when you discuss it with Sharia judges in Jordan, you get the occasional eye roll and, yeah, the Tunisians, they are doing something completely different again. They are outside of the framework of what is considered legitimate Islamic law. So probably the debate in Jordan is a little bit more representative of how inheritance is normally debated in other countries in the region. So whereas in most areas of family law, we have seen numerous countries amending different parts of family laws relating to the marriage age, polygamy, divorce rights, and so forth, especially since the 1990s. Inheritance has somehow been the elephant in the room. And this was no different when the Jordanian law was reformed and the new family code was issued in 2010. So prior to the issuing of the new code, women's groups in Jordan did not openly advocate for equality in inheritance between men and women. And that had different reasons. Even though a lot of activists in private would express their preference for an egalitarian law, but they thought that this wouldn't pass and it would poison other areas of reform, and it was smarter to kind of tone down the demands with respect to inheritance to push other avenues of reform of other issues. And this was partly the case because inheritance is laid out at least partly in the Quran. Actually, there are only 8 verses in the Quran, and Nadjma is going to talk more about this, but it's perceived as the most difficult area of reform by activists because there are Quranic stipulations on inheritance. And so instead of calling for equal inheritance between men and women, the Jordanian National Commission for Women, which is kind of a ministry of women's affairs in Jordan, so a state body, focused on increasing judicial oversight over inheritance procedures and reforming the procedural law. So not focusing on substantive law reform, but on procedural law reform. And this approach was motivated also by a study the Jordanian National Forum for Women had carried out in the governorate of Irbid. Irbid is the second largest city in Jordan, in the north of Amman. And they carried out a study in 2010, and they found that 74% of women who were interviewed for this study did not receive their full legal inheritance share. So the study was based on women between the age of 25 and 50, and it surveyed 1,372 families in all of the districts of the governorate of Irbid. And I mean, there were different reasons why these women didn't receive their full inheritance share. So a lot of women said that they were pressured to give up their inheritance. Others said that they felt that their rights were more secured within their family network if they renounced their inheritance share in favor of a brother or a male sibling. And others did not receive their inheritance share because the inheritance had not been divided, sometimes especially because in Jordan a lot of the inheritance concerns land, and it's often difficult to divide the inheritance because different parties have to renounce their share in order for the inheritance to be divided. So women overall often renounce their inheritance share, and I should say that so takharush, this procedure of renouncing your inheritance share, is part of the overall procedure of inheritance, and it's normal and it's important and it's necessary because often what is inherited is land, and the land needs to be divided between several heirs, so some heirs need to renounce their share in order for the inheritance to be divided. But the problem is that women often do not get compensated for the share they are renouncing. So even when they're not inheriting land, but even if they give up the land, often they don't get a compensation for what they are renouncing. So, and also the study also found that a lot of honor crimes were actually not motivated by sexual misconduct, but by women refusing to renounce their inheritance share in favor of a male sibling. So instead of calling for equal inheritance, the Jordanian National Commission asked to change the procedures for renouncing the inheritance shares. So this was motivated first of all by the perception that it's difficult to reform inheritance law because it's laid out in the Quran, and because this empirical evidence had shown that actually women were not receiving their legal inheritance share because of customary practices. So they wanted to guarantee that women were actually given and receiving their legal inheritance share rather than advocating for equality between men and women. So they asked that women should not be able to renounce their inheritance within a period of 1 year. So when the father passes away, there should be a period of 1 year during which women can, first of all, learn what the actual inheritance is, because very often they would give up their inheritance and they later find out that there is another piece of land in a different city and so forth, and to kind of get to grips with the grief and to make a rational, more informed decision about whether or not they want to renounce their share. So this demand was actually addressed by the 2010 law. So Article 319 of the 2010 law stipulates that the Qadi al-Qudat, which is the administration of the Sharia courts, will issue talimat, so provisions that will regulate how somebody can renounce an inheritance share. And those provisions were issued in 2011, and they basically declare that everybody, of course the main addressee are women here, needs to know what exactly they're renouncing, so there needs to be transparency about what you're giving up, and you need to be compensated. It's still possible to renounce your inheritance, but it's the provisions install a 3-month period. So the 1-year period the Jordanian National Commission for Women had asked for was not adopted, but a 3-month period during which women cannot, or anybody can not renounce their inheritance. And yes, there are, of course, exceptions, so the provisions allow for exceptions, and when you interview Sharia judges, they would normally say these exceptions to the 3-month period would concern cases in which the family lives abroad and they have to travel back to Jordan for the funeral, and then they fly out before the 3-month period passes, so they are, it's obligatory for them that this inheritance issue is regulated before that. So there are ways to opt out of this system. It's difficult to determine what the effect of this change in procedure was, partly because so we have statistics about the application of family law in Jordan, but only since 2010 do these statistics get published regularly, so annually, so when the new law was issued. And these statistics are, so we know the total number of taharush cases, but we don't know, it's not gender specific, so we don't know how many women renounce their inheritance share, we don't know how many men. We can see that the number of these cases remains relatively stable, which is also normal because, as I explained, it's necessary to be able to renounce your inheritance share because you're often inheriting land or a house or whatever. So it's a part of the overall procedure of inheritance. Interviews with Sharia judges reveal that they have, I think, become a little bit more sensitive to the issue of female inheritance. And so one judge, for example, the chancellor of the Qadi al-Qudat, he said that they now, for example, if after a period of 2 years, the woman discovers that the father had a piece of land in a different city, that would then, which had been hidden by her brothers or so forth, that would then not be registered under the first taharush case, so when she renounced her inheritance, but that would be a new case. So she could still claim her share on this second piece of land. And they would make sure that the women get a compensation normally in terms of money that would actually be on an equal footing with the value of the land. So overall, it's difficult to assess the effects of this change in procedure. I think there needs to be more research done on this, but it's an interesting way to address the elephant in the room, without actually causing a lot of outrage in society. And it's actually, I mean, it's become, people talk about it more, it's become more acceptable to discuss it within families, and it's probably, it's a less controversial way into the inheritance debate than actually advocating for equality of men and women right away. So I think my time is up.
Thank you, Dörthe. I do need to read the title of the project that you're a leader of, Nadjma. So Nadjma Yassari is at the Max Planck Institute for Comparative International Private Law, and the research group that she's a leader of is, quote, Changes in God's Law, an inner Islamic comparison of family and succession laws at the Institute. And so Nadjma will take us to the more procedure, or will share with us some remarks or some comments on the, with this perspective, this wider perspective of your project on the legislative reform process in family law. Please.
Yeah. So we have a group, and we were working on family law mainly in the last 10 or so years. And recently we've started to get more interested in succession law. Now, succession law is something that needs a broad intensity of knowledge, because you need to know family law, you need to know succession law, you need to know mathematics, basically, if you do Islamic law. But you need also to know how does property devolve, what is property law, what is all these other regions of law that you really need to understand to get into succession law. So we took some time to get into it, but we decided to do that. And one of the questions that we addressed in the beginning was, why is there no reform in succession law as much as there is reform in family law? Why do legislatures don't tackle family law? And what should be tackled? What needs to be looked at when we look at succession law in Muslim countries or Muslim jurisdictions? Now, there is a variety of problematic situations, if you call it, caused by Muslim succession law, and I'm just going to talk about intestate succession. So what happens if there is no testator to testate to his will? So this would be another chapter again to look at. But what is the problematic issue in the codifications or the uncodified regulations of various schools of law in Islamic law? So Hanafi, Maliki, Hanbali, and Shafi'i would be different. So that again would be like different things to look at. How do the different madhab do that? But what are the variety of problematic situations? There is gender equality, obviously, as the main thing that we look at. But it's not the only problematic or like issue that we need to look at. The second is position of grandchildren and the idea of representation. There is no representation on the classical Islamic law as a general rule. Obviously, there are differences in the madhabs. But there is, if you have a predeceased child, the grandchildren will not inherit if you have still other children alive, as a general idea, because there is an idea of closeness to the deceased. There is the problematic position of non-Muslims. We have countries where we have interreligious marriages, and there's always the questions of the inheritance share, mostly of the non-Muslim wife, whereas the Sunnis say there is no inheritance rights between Muslims and non-Muslims. In Shia law, for example, the Muslim takes it all. So if you have a Christian family and one of the heirs would convert to Islam, that person would exclude all the other heirs in the family. And we have cases like this in Iran. So there's the position of the non-Muslim heir. There's the position of the surviving spouse, which is obviously a gender issue, but it's also a question of what does she inherit. So we have the factual problems that sometimes female heirs don't inherit, as you said, or don't get their share, despite that they have a right to inherit. But we have problems with the surviving spouse in terms of the quantity of what she's getting, half of what the surviving man would inherit if he had survived. But we also have some issues, not in Sunni countries, but we have also issues on what she can inherit, because under Shia law she doesn't inherit the land and the buildings on the land as such. It just gets a share of the value of those things, and that's also a new, there's a lot of controversy on that. And then obviously the position of the asaba is a problem, the position of the male relatives who trace the line by male lines to the deceased, so the uncle, the sons of the sons in competition, the fathers and the grandfathers, all these male who are called the agnats, who cause problems because they always come into the nuclear family who thinks that the richesse de la famille, the wealth of the family, should go by generations in a straight line and not in the collaterals. So there are a lot of problems. And the question for the legislature would be, and the question that the Tunisian have to ask themselves is, do we dismantle the whole system? Because that goes through all the regulations of succession. If we try to change a little bit on here and change a little bit on that, the system would not be coherent anymore. And if we change succession law, we will need to change family law, because the reason for the double share of man in inheritance is their duty, their obligation to support the family, and not only the spouse, but also the children. And so we have a balance of rights and duties that in itself makes sense, but if you try to change the balance, the balance changes and then it becomes unequal on the other side. So do we dismantle the system, or do we amend the most burning issue? And as I understood, the Tunisians said, let's tackle the most burning issues first, maybe. So why is it so difficult to make that choice, and why is it difficult to tackle succession law? So there is this this idea that it's in the Quran, and the Quran says how it works. Well, you know, there are over 6,000 verses in the Quran, and there are 8 verses on inheritance. And I wrote them down, and it's like, just to give you an idea, there are 4 of them deal with general principles regarding access to succession. One deals with the shares of the children and the parents of the deceased, one with the share of the spouses, and 2 address the share of the siblings of the deceased. The bulk of the rules and regulations on inheritance and succession law are based on the Sunnah, okay, and on the fiqh. So on the ways these verses and the Sunnah have been interpreted. So it's the place where human agency has been the most. If you compare it with family law regulations deriving from the Quran, you will see that there are much more verses related to family law. And still we say in family law, nobody said we cannot reform family law because it's in the Quran. But it seems that there is something about succession which touches much more on our emotions, or on the core of what we believe is the center of Islamic law. And I think that the amount of the verses cannot be the reason. So what could be other reasons? So one reason that could be seen is that there is a idea of when death comes, there should be some divine rule on what happens next. So this is maybe a little bit, yeah, just what I thought of. Maybe there's something of a submission to something higher when you die, because in family law you generally don't die. So there is somebody you can engage with, but there's always a death in succession law. So maybe there's this idea of, I don't know, maybe we can discuss this. The second one is what Dörthe addressed, is that sometimes female bargain the right of inheritance for wider support with their brothers. So sometimes because of the social circumstances, it could be seen as something that is worthwhile doing. I give up my rights on the land, but I will be sure that my brother will protect me whatever happens to me in my family relations or whatever. So that could be one. This is also an argument that Annelies Moos has put forward. And the third reason I could come up with why there is a slow impetus for reform is probably, and I can say that from experience in my own family, that people would try to divide the family assets while they're alive. So there is a bulk of transactions inter vivos that makes you have still control over your property, because under Islamic law, as a general rule again, you can dispose of your property as long as you're alive until the moment you get sick and die. But if you don't get sick, you can actually give away anything until the moment you die. But then you die and the disposition is. So there is a great unlimited freedom to dispose of your wealth while you're alive, and taken away from you in view of your death. And so there are lots of this is just an hypothesis. I don't know whether it really happens, but this is how we try to explain why there's no real movement to change succession law as well, is that people try to order their wealth before they die. And there is a very nice article by David Powers who describes this already in the 14th century. So this could be three reasons. There could be also that succession law has an idea of power relation between the people involved in that we still can dwell on. So with these reasons, we might think of how can we still go on to the reforms? What kind of tools do we have? There's a public debate. It's good that people start to talk about it, when it's demystifying something when you start talking about it, even if, as you said, people don't know much about it, but still it's an issue. People talk about it. The question is, should we try to reform succession law in an Islamic discourse? Should we get make the girl an agnatic, treat her as an agnatic son? Yeah. Is that reasonable? It's a question that we can ask. Shall we use Islamic discourse to do that? How does it have to look into different madhabs? So can we go back to Takhayyur and Takfir and all the things that we did, the Islamic methods, to like look to the Shia madhab and say, well, you know, the daughters always exclude anybody else who's a male agnat. There is no male agnat. My uncle is not going to get anything from my father, at least. So the other question is the autonomy of the parties. How far do we get that? So you said the Tunisian system is a default system with an opt-in position for the one who wants to go back to the discriminator. But an opt-in position, we have the system in Tunisia for matrimonial property regime. Yeah? In the other direction. So maybe to see how it could work for succession law, we could draw on the experiences that we have on matrimonial property regime. So in Tunisia you have the system of separation of goods, but you can opt into the community of goods, which is difficult to do. In Tunisia, in Indonesia it's the contrary. You have a legal situation of the community of goods, and you have to opt out of it if you want to do that. So that's obviously better for the weaker, the less wealthy person. So how do we play with opt-in, opt-out? I think that could be also something that one can think about it. And I'm going to leave it at because my 2 minutes are over. But it's just some ideas of it's not that clear. We want to reform something, but we have to get an idea of a holistic view of what is actually at stake. Thank you.
Okay, so as according to the plan, she will respond now to the comments, and then we will open the floor. I already have someone who put their name down, so just prepare your questions. Oh, there we go, it happened. I thought you wanted to respond.
D'accord, pardon. D'accord, j'ai une brièvement pour Roberta. Non, on a dit le conjoint dans le rapport. Donc le conjoint, c'est Karim. Karim, c'est l'homme ou la femme. On a fait attention à ça, même si dans la plupart des cas,
dans le même article, il y a écrit Eftauj.
Parce que
Karim ou Eftauj.
Oui, même.
Ah, I'm sorry.
Dans le sens, le conjoint. D'accord. D'ailleurs, même on a traduit en français, c'est le conjoint, même si la question a été discutée, parce que on a dit au départ, en général, le mari c'est le propriétaire de la maison. Et pourquoi est-ce qu'on accorde ça à la femme? Parce que sa part, elle est trop petite, donc en général, les enfants pas en général, enfin, ça arrive, mais comme elle a une petite part, donc elle est exclue par les enfants, donc c'est ça. Alors pour le reste, j'avoue que nous-mêmes, on a fait beaucoup d'acrobaties juridiques, et c'est pour ça qu'on a commencé en disant il faut tout revoir. Parce qu'on a essayé même de toucher les oncles, les tantes, il faut 3 ans de travail. Parce que donc là, il y a un petit bricolage, mais on a dit on se limite au degré, enfin là où c'est l'AGNA qui est là. Donc nous, c'est vrai que actuellement, même si la loi sera adoptée, ça sera un système hybride. Et donc il va falloir tout revoir. Alors pour Nadjma, je ne suis pas sûre de bien comprendre. Tu as évoqué le régime des biens entre époux. Précisément, on voulait éviter cela. On voulait éviter de faire un double régime juridique double, c'est-à-dire au choix, un genre de choix qui serait communautariste un peu, c'est-à-dire il y aura ceux qui vont opter pour la charia donc, et ceux qui, non, on a dit l'état civil, c'est l'égalité pour tous. Maintenant, s'il y a ceux qui résistent, et on compte sur le temps aussi, parce qu'au début, il y aura peut-être beaucoup de gens qui vont faire revenir à la discrimination, ou vont revendiquer la discrimination, mais avec un travail de sensibilisation, ça va diminuer par le temps, parce que rien que vis-à-vis de leurs filles, garçons, on a du mal à dire à sa fille, je te donne de mon vivant, je décide, j'insiste que tu prennes la moitié. Donc on voulait éviter le double régime. Voilà, si je viens...
So I suppose I need to give a little background of what just happened. So I think that Salwa was responding to the question of Roberta about the presence in the same provision of two terms that would suggest a significant gender disequality with the presence of the word qarin and the presence of the word zawj. So zawj is, I would say, traditionally more associated with the male, whereas qarin is most probably the most neutral one. Salwa was, I think, was proposing a resemantization of zawj in the sense of let's treat zawj as a gender neutral. It's just the spouse. Whereas, I mean, traditionally, especially if you have two words in the same provision, qarin and zawj, you tend to interpret the one as spouse and the other one as husband. Second response, but here I need a lot because they are very French, the acrobatie, le bricolage. No, I'm a bit... So the question was about the approach, the hybrid approach to the reform, and so Salwa acknowledged that it is a hybrid approach, so they did try to work with the existing tools and introduce new solutions. On the last question on the matrimonial property regime, Salwa responded with Nadjma's point. Insisted that given how problematic gender equality in inheritance is, it must be the default system that then you need to adopt. Is the solution that was the second proposal of the Commission that was then adopted by the government in its draft bill. All right. So, is there looking for a qarin or a zawj? I can open the floor. I have a request for comment. However, given the time, I'm so proud we actually have the full half hour. But I would ask you to, be brief because you asked for 5 minutes, and I don't think we can allow for 5 minutes. Yeah, I'm gonna have. And yeah, I'll give it a. No. This is dangerous. But let me turn it on for you.
I can talk.
Oh, it's on. It's on.
Is it?
It's on. There is a light on.
Oh, that's true.
Yeah.
Yes, that's right. Good afternoon. Yes, absolutely. Good afternoon. My name is Salah Mukhtar. I'm president of the Arab Lawyers Association in the UK. First of all, it's very opportune to have this debate today. It's the 100th anniversary of women's rights, 1919. The second thing is that I would like to say that commend Tunis among all the Arab countries for the advancement in its legislation, not only now, but even during Bourguiba time. And as far as post the revolution in Tunis, they've advanced even more so. I think as far as the issue of the equality, I think what we are dealing with is a socio-political issue. And I think we must recognize that at the end of the day, it is the populace who will decide. It's not the activists and not the religious leaders. So if the society does not feel that this process is right, then that is what's going to happen. I have a feeling in Tunisia is going to go through that process. Unfortunately, I think it's mostly a political one between quote-unquote Islamists and quote-unquote un-Islamists. It is more of a political exercise. I think it needs reform. I disagree about the idea that why inheritance is an issue that is difficult. Looking at 10 verses in the Quran is not a good measure. This is the only subject in the Quran that is addressed in so much details. That's where the difficulty comes from. If you look at, there are many, many other verses which deals with children and family and all the rest of it, but they don't have that much of details. This one is so detailed, it is difficult to tinker with. That doesn't mean we shouldn't try and make the changes if it's possible and if the people want. The last thing I want to say is this. We have to distinguish between what we're talking about between Islamic Sharia as it stands in the madahib and schools and the legislation. Tunis and all the Arab countries, and I think all the Muslim countries, in fact, they have codified their family law. So what we are addressing is not a Sharia issue, it's more of a codification of the law. Thank you very much.
Hi, Lynn Welshman from SOAS. Well done, everybody. I really Salwa أول إشي طبعا. Thank you very much. And well done on the work. I'm following it from afar, but very impressed. And I managed to get a brief sommaire of the report, but I will read that. I haven't got the 20 pages yet, so I look forward to the introduction. Roberta. I wanted my quick to Dörthe, of course. I have to respond to Dörthe because she used to be my student. I'm allowed to say that. So. I'm very proud of Dörthe's book coming out. And I wanted to say something else I'm quite proud of because it doesn't always happen, but it sounds like a competitive thing. It's just that, Palestine was actually before Jordan in doing those procedural things on inheritance. I just wanted to say that because we had quite an activist, Khalil Qudra, at the time, and in 2000 he issued Dalimet about saying that you cannot do what he said, that women, nobody could waive their inheritance rights until all the inheritance had been brought together, and actually the woman would be told, this is what you get, and this is what it's worth. And then she would be allowed to do the order, and she had to do it in court in front of in person. So those procedural things are so important in making people think about it, and when they do decide to do it, knowing what they have to bargain with. So I agree absolutely on that, but I just wanted to say Palestine did it first.
Thank you. Yeah, I have all of you who have showed their hands are in my head.
Thank you very much. Thank you so much for your excellent presentation. I have been following the Kolib, and I happen to know Iqbal Qarbi very well, and Iqbal Qarbi, who is part of Kolib. Qarbi? Oh, no. I thought she was part of the Commission. Anyway, I have two questions. One is the equality of inheritance among the different family members now in Tunisia irrespective of religion of any one of the family members? For example, if the wife is not Muslim, is she able to inherit the same or not? And that goes back to what you were saying as well. Another question that I have pertains to your description of unequal inheritance as a form of violence économique, which I think is true, but it is mainly true for women from lower income families. I wonder if within the Commission, if you have discussed how unequal inheritance adversely affects lower income households and women more than upper income, because the women, les femmes professionnelles, par exemple, I mean, on a des biens d'eux-mêmes, etc. But the working class and lower income women who do not work, for example, they are more adversely affected by unequal inheritance. So does the class issue come into your discussions at all? Thank you.
Thank you very much for your very interesting presentations. First presenter, and anyone can answer. So the first presenter talked about the Bach, the Garden of Fadak, which Hazrat Fatima actually claimed as her inheritance, and she was not given initially, and she had to fight for that. And then you mentioned that Sunnis and Shiahs actually follow different type of, they have difference in terms of dealing with their inheritance law. I'm just wondering, what is the difference between Shiahs and Sunnis in Tunisia when it comes to deal with gender equality? And the other thing is that, is there a Muslim country, a single Muslim country in the world where gender equality is practiced between male and female? That is, I just want.
Thank you very much, Dr. Salwa and the other presenters. I found 2 points very interesting in your presentation. One about debate, that the most important thing about the proposal is opening debate on this important issue. And like you said, for political considerations, perhaps this law won't be passed anytime soon. So that thing is very important, the debate, opening the debate. However, do you think there are positive factors that would facilitate this debate and make it effective in the current situation? I found, for instance, interesting the fact that you used in the report religious arguments to justify this reform. However, I've been following the debate, and in the media there isn't really so much the use of religious justifications and in detail of the reform, and there is this half-hearted use of religious arguments, whereas at the same time we emphasize that the law is positive law, and it's not based on fiqh, and it's not based on religion. So we have a polarization. We have those who present the report as a violation of religion, and we have also, apart from the political considerations of the parties and the electoral campaigns, the fact that many surveys say that a vast majority of people are against this reform. So the debate and the justifications and the arguments we will use are very important. But we have, as I said, polarization between those who see this as a fixed religious issue and those who are reluctant to use really religious arguments to convince those on the other side. So how do you see this debate going forward?
Thank you. My question is slightly more fundamental. Looking at the factor of reform from the Tanzimat time, I'm thinking that, touching on what Professor Aluffi adverted to, that while the reform process is very much based on modern constitutional thinking, are we looking at modern constitutional thinking which seems to be post-modern, and then looking at how to accommodate that with classical Sharia, which may be not at the same stage? Do we need a new theory of law, like Maqasid-based theory of law, to see whether this reform will find Islamic purchase? Shouldn't sound like it's imposed from outside Muslim thought. And I'm wondering, is there something more fundamental that needs to be done while the discourse is to continue?
If it's a good 2019 conference touching on Islamic law, we need to say the word maqasid. So, alhamdulillah. Sorry, we have Abu first.
Thank you very much. I think Tunisians are far advanced. Then it goes back to Borgia time in 56. You see some of the reforms the advocate, etc. I'm just wondering, to cut shades of inheritance, you say, one has to go to fundamental things. When the Prophet, you see, the very fact that he banned female infanticide, he adult justice, equality as such, the very fact that in the United Nations General Assembly on Convention of this, I wonder whether we need this arcane rule of inheritance, you say. It can be very simple. I'm attracted to Musawa, the formation where they advocated some of this, and I found recently the troublesome at Syrian women complaining that the husband dies in these problems. That there has been a lot of problem about implementing Sharia law. I just wonder whether you will comment on this.
Thank you. Assalamu alaikum. We want to thank the gentleman over there for kicking off the concept of maqasid al-Sharia. To talk to your point, Nadjma, about where do we have this discourse, I think it is absolutely necessary that we have it in an Islamic context, because that's when we get, as the gentleman mentioned, you get the population on board. Otherwise, there have been attempts at gender parity in inheritance. Iraq did it in 1959 and reversed in 63, and Somalia did it in 75. It's never worked when it's been done as positive law. It has to be done within the discourse of what is maqasid al-Sharia. And we've managed to sort of reverse slavery. It's as significant, and that is very much within the concept of what was the intent of Islam. To your point about not changing many laws in inheritance but doing so in personal status, I'll disagree, because in most Muslim majority nations now we have wasi al-wajiba, the inheritance of grandchildren, and we also have worth al-warith. An heir can be given an additional 1/3, which is theoretically against the laws of inheritance. And the final point I just want to make is the concept of opting in and opting out. One of the, everyone is now sort of enamored by Muhammad Shahrur, who actually says the default is a wasiyah. The default is a will. The absence of a will kicks in the distribution as per the Quran. So even within the Islamic discourse, we can go back and revisit the concept of whether these rules are obligatory or whether they only kick in when there isn't a will.
Thank you. Then we have one last question, and then the closing by the speakers.
You said that the Commission made reference to 8 cases of women inheriting equal shares in the inheritance. Did you by any chance refer to Ibn Hanbal giving equal shares to his grandchildren in inheritance?
Should we go back the opposite way? So, and also, I mean, there were many things that were also common, so feel free to.
Yeah, I'm not going to comment on the intensity of the 8 verses on the Quran, because I'm not a faqih. I'm just a jurist. I just look at it, and I just look at, and this is my opinion on it. So we can discuss this if you want, but I still don't think that this is a good reason to say because it's detailed, because there are other detailed reasons to. This is just, but we can discuss this. This is just my view. I think that. So I'm just gonna give a question back. The female inheriting equal shares. I just know it from the Shia succession, which is when it's in the group within the female line, they will get the same shares. But I don't know if the Sunni are doing the same. But that would be one of the things. The wasiya wajiba is like a never-ending story. We started to work on it. We took out Ibn Hazm and we read everything about him. We were like the experts on Ibn Hazm to understand what he actually said, and we didn't really understand what he said. We're still going to dig into that. But the wasiya wajiba is a very difficult instrument because it touches about wasiya, which is voluntarily, and wajiba, which is not. And you don't know, do we place it into interstate succession, do we place it in testate succession? There is a rule in I don't know the countries, they only look at the boys, the grand boys, and they look only by the children from the daughter, or only the children. So it's a very complicated thing, and I think the most contentious issue is it destroys the freedom of testation of the testator. There is no freedom of testation if you have a wasiya wajiba, because there's nothing to give anymore, because you have to give it to a grandchild. And then it shakes up the shares of everybody else. So I just thought it through to Egypt and I don't know, another country, I don't remember. It was so complicated that I tried to, it's really complicated. And the Pakistani version is better because it's the idea of representation without a gender bias. So can we say that we can install in an Islamic discourse representation? That would be a discussion of the faqih who have to do that, and then we can look at them. But we need those people, those really learned scholars of Islamic law, to come up and tell us what they think, and not. And I do agree with you that the populists will win the elections, most probably. But we as academics, we really need to get in touch with those people who are really learned and who can inform us about how they work. So this is the so, and then you said something about the default route. What was that? Oh yeah. This also very, very controversial. There is this idea: is interstate the rule or is testate the rule? Is that default or I don't think that we can reinvent the wheel. There is this discussion about it. And I'm not the faqih. I'm just looking at science, at the literature, and saying the people are discussing about this. This happened I don't know. But what I know as a jurist of contemporary law, I have to say, how do I deal with the issues that come up with it? What is the function of succession? Why do we need succession law, and what is the aim of it? So how can we adapt it to the idea of where it comes from, like understand the idea where it comes from its Islamic basis, but then we transform it anyways when we codify it, or when we try to adapt it to contemporary social situations. So I'm not sure discussing whether it's a default or not. It's what does it do today to us, which is of my interest. So that would be my comment.
Yes, thank you, Lynn, for bringing up Palestine. Yes, it's surprising because, I mean, the renouncing of the inheritance is a good example, but there are other examples with respect, for example, to khul, which was discussed in a very similar fashion in Palestine without ever mentioning the debate in Jordan. So often you have these two debates that are happening parallel or shortly after each other, but there's no mentioning of the other. And I think partly that's the case because of the occupation. It's difficult to move back and forth for people, so there isn't a lot of exchange. But yeah, it's a mystery to me as well sometimes, and especially with the khul provisions when the Qadi al-Qudda in Palestine came up with all these new ideas that were basically Jordanian law. And well, yes. And then on the issue of public debate, I just wanted to add that yes, I mean in general, I guess it's a good thing to have public debate about inheritance, but I think what it did in Jordan, so in Jordan the parliament voted against the wasiya al-wajiba for female grandchildren in April. And I think one of the reasons was actually the debate in Tunisia. So they did not want to open inheritance at all. And this increased discussion about debate, inheritance in Tunisia and equal inheritance of men and women, and also, which we haven't mentioned, but which is also an important factor, is the debate within Christian communities. And because in Jordan, for example, the Christians are working on an inheritance law at the moment, which, as it seems, will stipulate gender equality for men and women. And in Syria, you have Christian communities, the Catholics in 2006, who adopted a new inheritance law which stipulates equality for men and women, and then in 2012 the Armenian Orthodox community who issued their own inheritance law. So those debates are happening, and of course the fear is that these inheritance laws for Christians will also reflect back or open the debate about Islamic inheritance law. So I think it's a very sensitive moment for different reasons. Thank you.
Thank you. I wasn't addressed by any question, but I want to thank you, all the people here, for their questions. I have no answer. I have further questions. Really, it is very challenging. For example, the link between marital property and equality in succession. I was wondering whether one should take into consideration also how sure are the two ways to get property. For example, I was wondering why in Tunisia apparently the possibility of shared marital property is not so used. Maybe because of the impossibility of registration. I mean, it's not so sure for translate, whereas succession, to get something from succession is a very sure way to get it.
Merci. Bon, je vais essayer de résumer. J'ai beaucoup de questions, mais je vais les ramasser un petit peu. Il y a des recoupements entre les questions. Alors, d'abord, pour l'idée que c'est le peuple ou la société qui décide. J'avoue que ce sujet-là, on en a longuement parlé. C'est quoi la question? C'est une approche, c'est un choix. C'est soit on va dire, allez, le droit ne peut jamais faire ce que la société refuse. Et dans ce cas, le droit va suivre un petit peu la société aussi. Donc l'État se soumet aux traditions, à la société. Et là, je ne vois pas, franchement, si on a appliqué ça en 1956, on n'aurait jamais eu le code du statut personnel, parce que ce n'était pas une demande de la société. Soit alors on dit que le droit, c'est une locomotive, c'est quelque chose qui hausse la société et qui essaye d'éduquer la population. Bien sûr, on ne le fait pas d'une manière verticale, comme dans un pays qui n'est pas démocratique. Bourguiba l'a fait d'une manière verticale. Mais là, on essaie de convaincre, on discute, on parle de ça pour y arriver. Donc ça, moi, je vois le rôle du droit comme ça. Alors, pour votre question sur l'égalité entre musulmans et dans l'héritage entre musulmans et non-musulmans, dans notre projet, nous, on a mis clairement qu'il ne fallait pas que la disparité des cultes soit une raison de discrimination dans l'héritage. Mais ça n'a pas été repris par le projet, sachant que notre jurisprudence, elle est instable sur cette question. Nous avons la Cour de cassation qui n'a pas totalement tranché. Donc nous avons des décisions, des arrêts de la Cour de cassation où on dit qu'il y a disparité entre les cultes, donc même une femme dont le mari est décédé a été privée d'héritage, ainsi de suite. On a d'autres décisions, ça dépend des chambres en fait, et donc ça dépend de l'interprétation. Ça veut dire encore une fois que le texte, n'importe quel texte, n'existe que par la bouche de celui qui l'interprète. Donc on a d'autres chambres qui ont décidé autrement, qui sont revenus au pacte des droits civils et qui ont dit c'est l'égalité, donc c'est une obligation internationale, donc c'est l'égalité malgré la disparité des cultes. On voulait clore ce débat à travers cette disposition. Bon, ça n'a pas été retenu. Alors pour la violence économique, en fait, oui. Alors en Tunisie, il n'y a pas de différence dans les salaires entre femmes et hommes, mais sur la question des femmes qui ne travaillent pas, les femmes qui ne travaillent pas, on a pris ça en considération d'abord pour les exigences de la pension alimentaire. Et là, j'en profite pour rappeler que, je ne sais plus, quelqu'un ici parlait de Nadjma, peut-être de l'équilibre entre les devoirs, c'est-à-dire l'obligation de la pension n'est exigible que lorsque le mari dispose de moyens et que surtout la femme n'en dispose pas. Donc on a obligé dans le projet la femme réellement de dépenser. On a revu la dot et donc on a renoncé à la notion de chef de famille parce que maintenant on dit que l'homme hérite le double, c'est parce que c'est lui qui dépense, c'est lui le chef des familles, c'est lui. Donc on a essayé de revoir les autres obligations aussi et on a pris en considération les femmes qui ne travaillent pas, sachant que sur le plan économique, on dit les femmes ne travaillent pas, mais il y a ce qu'on appelle le travail invisible des femmes aussi, et donc en attendant l'autonomisation de la femme, on a prévu cela. Dernière chose, peut-être par rapport à la question économique, on nous a sorti aussi l'idée que la question de l'égalité dans l'héritage, c'est une affaire de riches. Il faut avoir de quoi hériter. C'est la bourgeoisie. Mais non, c'est pas vrai. C'est pas vrai. Même la femme pauvre, la femme rurale, les femmes qui travaillent tout le temps, mais qui n'arrivent pas à. Vous savez que dans les milieux ruraux, seulement 3% des femmes disposent de propriété, alors qu'elles travaillent dans les champs jour et nuit. Et donc, la question des classes sociales ne se pose pas, parce qu'une égalité dans l'héritage, elle est aussi bénéfique, elle est plus bénéfique, je dirais, pour la femme pauvre que pour la femme qui dispose d'autres revenus. Sur le débat, la bipolarisation du débat, alors c'est vrai qu'on n'a pas pu éviter ceci et on est revenu à l'ambiance d'avant 2014. Moi, je pense qu'il faut qu'il y ait un débat de bonne foi. C'est-à-dire, il faut que ceux qui veulent défendre, par exemple, l'aspect religieux soient ouverts pour écouter. Si on dit qu'on applique le Coran, on applique ce verset parce que le Coran le dit, il faut répondre aussi sur d'autres versets aussi clairs, sur les hudud, sur les châtiments corporels, sur beaucoup d'autres choses. Donc c'est une question. Je pense que l'argument le plus important, c'est pas de dire non, ça n'a rien à voir avec la religion. Et là aussi, on a beaucoup discuté de ça. L'introduction qu'on a faite, dans laquelle il y a l'aspect religieux, on a hésité. Est-ce qu'on fait quelque chose qui est en rapport avec la religion? Parce que nous, on n'était pas obligés de le faire. Hein. On avait la Constitution et les conventions. Alors, on a dit, puisque notre Constitution renvoie à maqasid al-Islam, maqasid, c'est pas le harf, le texte. Donc, c'est l'esprit de la religion. Est-ce qu'il y a dans l'esprit ou dans les buts ou dans les objectifs de notre religion quelque chose qui interdirait? Est-ce que c'est un péché de respecter l'égalité? On a essayé de démontrer en tout cas que ce n'est pas le cas, et à travers des exemples très importants. J'espère qu'il n'y aura pas de bipolarisation par rapport à cela, et que moi, le défi, franchement, pour moi, le défi, c'est de voir des gens croyants, pratiquants, qui acceptent et qui comprennent que ce n'est pas l'essence de la religion, tout simplement. Voilà, donc je pense par là même, j'ai parlé des maqas par la même occasion. Alors voilà, je pense que j'ai répondu à toutes les questions, j'espère. Merci. Oui. Excusez-moi, parce que j'avais pas de réponse, tout simplement. Enfin, si j'ai bien compris, c'est le Hanafi.
Oui,
voilà.
Ibn Hanbal.
Vous avez dit si Ibn Hanbal a donné à ses enfants à part égale. Non.
Hein? Parce que vous avez mentionné pour
les 8 cas.
La commission
oui.
A fait référence à
oui.
8 cas.
Oui.
Où les femmes et les hommes ont reçu des pourcentages égaux.
Oui.
Et vous n'avez pas dit quel cas. Est-ce que vous avez fait référence à Ibn Hanbal?
Non, ce sont des cas d'abord très complexes, et surtout, on a fait référence pour les écarter en plus, parce que les cas d'égalité, ce n'est pas au même degré de parenté. Ça c'est très important. Les 8 cas d'égalité, ou même les autres cas où la femme hérite plus, ce n'est pas des cas similaires. Donc, même la comparaison ne tient pas. Quand est-ce qu'on doit comparer? On doit comparer à parenté égale. Moi et mon frère, vous et votre époux, ma tante et mon oncle. C'est-à-dire le degré de parenté doit être le même. Les autres cas qu'on cite souvent comme égalitaires ou pas, c'est, je ne sais pas, je dis n'importe quoi, hein, moi avec la cousine de mon oncle, mon oncle, ou je ne sais pas quoi. Donc, enfin, je schématise, hein, mais ce sont ces cas-là que nous avons évoqués pour dire que oui, ça existe. Donc, l'inégalité, ce n'est pas quelque chose de sacré. Il y a eu des cas d'égalité, tout simplement. Voilà, j'espère.
L'héritage de Khadija, ça a passé à Mohammed complètement.
Ah, je sais pas là. Je sais pas. Je ne vais pas me hasarder. Moi, je suis juriste. Moi-même, j'ai découvert beaucoup de choses à l'occasion de ce travail. Donc, peut-être d'autres.
Non, je sais pas.
Non, Khadija, donc je sais pas, franchement. Je sais pour Fatma, qui a été déshéritée, enfin, voilà.
All right. So many thanks. Just again. So the first question was on the issue of law and society. And Salwa evoked the 1956 personal status law, and she said we decided to go down a different road. That is, instead of having the autocratic approach of just imposing the law, we tried to go down the democratic road. On inheriting across religious affiliations, she pointed to the fact that the existing law depends on the case law of the Court of Cassation, and within the Court of Cassation, different chambers have different opinions. So it's not even an established case law on the point. On the question of the economy and the role that class plays in matters of inheritance, she also branched out on the issue of the balancing the rights and duties. But she of course recognized that those are interconnected questions that cannot be considered separately, and that the class dimension of the debate actually is not as perceived as affecting mostly the upper classes, but rather the lower and rural classes. When it comes to the polarization of the debate, 2 points. The answer that was given to those who wanted and said, we want to apply Sharia, then the answer was, okay, let's apply it all. So all the other aspects that, you guys don't want to apply, then if you are so insisting on inheritance, then let's take also the others on board. Second part is it was an aware choice of the Commission to bring in the religious argument, and she said we were not obliged because our framework was the text of the Constitution and international law obligations, but we decided to do that so as to engage in that debate with the wider public. And on the last point, the 8 cases that were cited in which there is equality, or even when women inherit more than men, Salwa emphasized the fact that there are different relations within these 8 cases. Marvelous. So I think it's quite interesting because considering a previous event that we had for the governance program on the European Court of Human Rights decision on the Mullah Salih versus Greece case, it was again a question of inheritance, the freedom to choose. And interestingly enough, the Greek legislator had actually opted for the freedom to choose. So I think it's interesting, and we've had not a heated, but a good discussion in that case as well, because this sort of approach to the right of option, or framing the question of inheritance as a right of option, seems to be like interesting on both sides. On both. Is already decision came through? Yeah. And they decided that she was right. They couldn't force it on her, on him, the propositors. Quick note, all the position papers or presentations are on the governance program webpage, so if you want to look at them, they're already there. The recording of this session will be on the website as well. I want to thank the governance program team and the other members of the Institute who have made this possible, even if they are no longer with us, tonight. I have to mention that we have one further event before the summer, which is on the 25th of June. We will have the launch of the book by Nancy Hoker, who is our 2019 fellow for the program. and the book is on Palestinian multilingualism, extremely interesting topic and stuff. And so please join me in thanking the speaker, and you have all a good night.